Welcome to episode 36 on the law report. Today we're going to discuss the topic of when can the police lawfully enter onto private property. Nothing that I say in this episode 36 should be construed as legal advice. For legal advice, please contact an attorney of your choice. In the famous and much quoted decision in the Samayne case in 1604, Sir Edward Coke, the English jurist, declared that the house of everyone is to him as his castle and fortress, as well for defense against injury and violence as for his repose. Over the years, this has been simplified as a man's home is his castle. The case establishes, in my view, certain common law principles, and I will mention two of them briefly. One, that the home is protected from forced entry in all but a couple of special circumstances. And two, if forced entry is used to enter the home, then equal force may be used to defend it. I'll be back shortly for a more detailed discussion. In general, the police do not have the right to enter a person's house or other private premises without their permission or without a warrant. However, they may enter without a warrant in the following circumstances. If in close pursuit, or what is normally referred to as hot pursuit of someone the police believes to have committed or have attempted to commit a serious offense, then the police, while giving chase to that person, may, in those prescribed circumstances, enter upon private property. The police may enter to sort out a disturbance. For example, a report is made, 911 call. The police could go to that residence where there is a dispute. If a police officer is passing a residence or a premises and he or she hears cries for help or someone is in distress and the police believes that there is an urgent situation, in those circumstances, the police could enter upon private premises without a warrant. Otherwise, the police entry upon private property is confined to the enforcement of an arrest warrant or a search warrant, the execution of a search warrant. If the officer or police officers are invited onto the premises and into the home by the occupant, someone with authority to do so, or if the law, a statute, specifically confer such power of entry to police officers, then the police can enter. Now, the police officer, like any ordinary citizen, has what is called an implied license to enter upon private property. So quite apart from any statutory power of entry, police officers have the same right as any other member of the public to go onto a private or residential property for a lawful purpose. In other words, the law implies a license for members of the public, including police officers, to go onto private property in order to make inquiries of the occupier for a reasonable purpose. It is also settled law that this implied license can be revoked expressly or by implication or for any reason by the person granting the license to enter upon private property. So if a police officer have been granted a license by a homeowner to enter upon private property, to enter into his home, and that license is expressly revoked by the person granting the license, the police officer must leave. And if he refuses to leave, he becomes a trespasser. And it doesn't matter whether he is in uniform or not. Once a license to enter is revoked expressly by implication or by an express notice verbally to leave, then that officer must leave, because consent to enter is withdrawn. In a recent High Court decision in New Zealand, it was an appeal from a conviction for failing to provide a breath specimen. The court accepted in that case that initially a constable had entered on property lawfully under the implied license and had gained tacit permission of the tenant to stay on the property to speak to the appellant. However, the court found that the appellant had made it clear to the police officer that he should leave in words sufficiently clear to revoke the constable's implied license to be present. The police officer in that case, the court found, was not relying on any statutory powers of entry. Accordingly, he was unlawfully on the property when he arrested the appellant. On that basis, the High Court crushed the appellant's conviction. The Canadian case of the Queen and Godoy of 1999, 2 police officers responded to a 911 call. The accused refused them entry, attempting to close the door, informing them that everything was okay. Officers heard a woman crying inside and pushed open the door, entered the premises or the house, where they found the accused's wife coiled up on the floor, injured. The court in that case held that public policy clearly requires that the police ab initio, at the very beginning, had the authority to investigate 911 calls. But while they may enter a dwelling house in the course of such investigation, depending on the circumstances of each case, if the police conduct constitute a prima facie interference with a person's liberty or property, the court must consider two questions. One, does the conduct fall within the general scope of any duty imposed by statute or recognized by the common law? And the second question the court must consider is, does the conduct, albeit within the general scope of such a duty, involve an unjustifiable use of powers associated with the duty? The court went on to say, some intrusion to protect life is within the public interest, but the intrusion should be limited to protect life and safety. The police don't have further permission to search premises or otherwise intrude on residents' privacy or property. So this is a case where the court held that because of some urgent situation, some emergency, the need to protect life, the police in those circumstances could enter upon property, but the entry was narrow in scope. It did not extend to searching the premises. So the takeaway from this, and please note that this is not legal advice, is that a police entering upon private property without a warrant or any emergency warranting the entry, implied license to enter such property could be revoked by the property owner or anyone with authority to do so. And this is whether the police officer is in uniform or not. Once the implied license is expressly revoked, if the officer remains on the property, he becomes a trespasser and may be liable to civil penalties under the civil law. Police cannot search private property without a warrant or without the consent of the owner of such property. Now, I am not giving legal advice, but in no circumstance, in my respectful view, should anyone give consent to the police to enter upon private property or into their homes, because once they open that Pandora's box. One never knows where it will lead. Police are notorious in abusing their power, and it cannot be guaranteed that they will operate within the scope that they will allow to enter upon private property. And if they do not have a warrant and there is no emergency warranting them to enter upon private property, respectfully ask them to leave. And if they remain on the property, they are trespassers. Here is where I will leave it for today. I will see you in another episode. Thank you for watching.